what defenses exist to a claim of copyright infringement? To start with, a party can claim that the original holder of the copyrights, that their copyright is invalid, that it never should have been issued. And this is an obvious defense to infringement because the individual trying to enforce the copyright does not have a valid copyright. Second, the infringer can show that they have a valid license to use the copyright in the way in which they're using it. So if they can demonstrate there's some express or implied license there, then again, that would be a defense. They could claim that the individual enforcing the copyright did not do so within the relevant statute of limitations. That is, after learning of the infringement, they waited and waited and waited past whatever statutory period is in place for enforcing those rights, and thereby forewent their ability to enforce that rights against others based on that statutory. There may be a defense for unknowing or unwitting infringement by the infringer. That is, they didn't know that somebody else had the copyright. This is generally only a defense or usable in situations where the infringement is not commercial in nature, that it's a private use of infringement, or the infringement is minor or minimal. And so this can be a defense. Another defense is that the copyright is already in the public domain, that it was turned over to the public domain by the copyright holder, or that it's past its period of statutory protection. So now it's in the public domain and anyone can use it. And then lastly is the fair use doctrine. And this is one that's commonly employed in academic circles, news media, etc. Fair use means that the copyrighted work is simply being used for a specific limited number of purposes that has some public benefit or advantage. First is to open it to public comment or critique. So if somebody writes a critique or article about it, about different aspects of it, then this critique is part of free expression and again, does not violate the holder of the copyright. Academic use, if the works, just excerpts from it, not the work in its entirety, but excerpts from it are used as exemplars, simply as teaching methods. In that case, the court would examine the extent of use, how much is used, is it excerpts, is it an entire thing, how was it presented in the academic context, etc. Then you have news or public comment. So if it's being reported upon by some press that's making comment or commentary about it, again, that would not infringe the mark. And then lastly, for comedy or satire. But all of these exceptions under fair use there are going to depend on the amount of the original work is used and how it's used in the public.